Good morning, everyone. It's very nice to see you. We're also covering Judge Cody's calendar this morning as well. Good morning, everyone. We're here in Rancho Bureau versus Whitfield. Two councils, please state your appearances for the record.
Michael Grant on behalf of the defendant Whitfield Regency Inc.
And it's love quickly, we have plaintiffs and the
Good morning. It's nice to see both of you. We are here on the motion for attorney's fees, which I had a chance to read. I know you had filed a motion in opposition seeking, indicating that it should be staged so there's a determination as to the prevailing party. Is that correct?
Yes,
I read that last evening. All right, you may proceed, Mr. Grant.
Thank you, Your Honor. On September 25th of last year, this court entered an order granting the motion to tax fees and costs. It's to entitlement. Today we're here to determine the amount. With me today I have Mr. John Jorgensen to testify as to the reasonableness as an expert as to the fees that we are seeking today.
Excellent.
This case was originally commenced in 2012, and today we're going to seek the recovery of $32,192 in attorney's fees. That's 98 hours and 98.1 hours in total costs totaling $513.44.
Let me ask you, counsel, is there any opposition to the award of cost in this matter?
There was one item we object to in the court's list, but other than that.
What was that one item?
It's on his first page, Your Honor. It's a mileage expense for him to drive to the courthouse.
Okay, all right. Yeah, we can't tax mileage to the courthouse, so let's cross that one out.
Okay.
But other than that, all the full amount of costs will be awarded to
Thank you.
the All right, now on the attorney's fees, any objection to the hourly rate? And we'll certainly have Mr. Jorgensen testify in just a moment.
No objection to the hourly rate.
So the hourly rate is stipulated to, and what about the amount of hours?
Objection on it.
Okay, that's fine. So we're just going to go through the amount of hours then.
Sure.
Let me go ahead and swear the witness. Can you raise your right hand? Do you promise to tell the truth, the whole truth, and nothing but the truth?
I do.
Please make yourself comfortable.
Yes.
Just want to step going up.
Right, whenever you're ready for examination.
Good morning, Mr. Jorgensen.
Good morning.
Can you please detail your legal background and education for the court?
University of Florida College of Law, graduated 1982, passed the bar October 1982, been practicing continuously in Palm Beach County since.
Okay. And are you customarily aware of the attorney's fees that are charged in commercial breach of contract cases in Palm Beach County, Florida?
I am. A large part of my practice involves commercial and real estate litigation, including landlord-tenant, any type of contractual litigation.
And have you been qualified as an expert witness as to the reasonableness of attorney's fees in the past?
I have.
And what have you done to prepare for today's hearing?
You contacted me late last fall. We had a discussion about the case. You gave me your file. I reviewed the file. Then I reviewed your billing records. Yesterday and this morning, to refresh my memory again, I looked at the operator pleadings online, and I looked at your billing again and went through it in the docket on the clerk's online.
Your Honor, I have a copy of my firm's fee ledger for this matter. If I may
Sure,
approach.
yeah, let's go ahead and mark that as exhibit 1.
Jorgensen, have you formulated an opinion as to the fee ledger and the reasonableness of attorney's fees sought to be collected today?
I have, and I have, yes.
And what is that opinion?
Well, the litigation went on for quite some time. Apparently, there was periods of time when it was dormant, but it started way back in 2010 and extended for a number of years. So I went through and looked at all the billing records and looked at the file. And so in my opinion, of course, the hourly rate's not contested at this point, but I considered that the number of hours that you spent on it, and I agree, and I believe that the hours spent, 98.1 hours, is a reasonable amount of time for this type of litigation and what was involved.
And in rendering your opinion, have you considered the Rule of Professional Conduct 4-1.5 as well as the Florida Patients Compensation Fund versus Roe, Florida Supreme Court case 472 Southern 2nd 1145?
I did, and I looked at the case to see what type of case it was. There's landlord-tenant breach of lease case. There's an alter ego theory in there, which is interesting. And there was an attempt to bring a negligence claim against the landlord as well. I understand that your law firm has been representing this particular landlord for many, many years. So there was an established relationship there. And it was just a typical commercial type of lease. So yes, I did consider the factors that rule.
And in your opinion, is the amount sought in attorney's fees $32,192 reasonable?
Yes, it is.
Nothing further
All
on.
right, cross-examination? Plus,
Yes. When you looked over the list of the items from, about the individual bills, did you notice what year this case was filed?
I did.
What year was that?
Well, the time going starts in 2010.
I understand it, but when was the case filed?
I don't know the exact date of the filing of the case.
Do you know the year?
I can look through the record and find it for you, but I don't recall the exact date.
It was filed in 2012.
Okay.
So for the first page and a fifth, you see the items, the work done before the case was filed. I don't think that's appropriate for the going long attorney to be defending the
isn't
case.
that related to the actions of the landlord-tenant situation though?
Some involve other issues, and some do not involve this, some involve,
Which time entries?
well, it's the first, it starts on, it's the first page and the first.
But this
second
relates to the
page.
3-day notice, I mean, it relates to.
No, that's not what it is. We started the case, they did.
Which one? Which entry?
So, review of correspondence with the property manager, telephone conference with tenants manager, receipt of correspondence from property manager, work regarding status update, receipt and review correspondence from property manager. These all occurred 2 years before there was a lawsuit or these issues.
I'm
in
sure
place.
counsel may testify that the dispute actually originates back from that time. So,
That's correct, Your Honor. And the lease provides that the lessee shall promptly pay the landlord all costs and expenses of collection, including reasonable attorney's fees, with respect to just about anything that has to do with interpretation or defense or prosecution of any claims arising out of the lease.
These are not collections, these are other arguments back and forth that are not part of this lawsuit.
okay, well, we're not gonna argue, let's finish cross-examination because I have a court report.
I understand
Okay.
that that's one of 3 items to mention.
So just tell me which date you're contesting.
Well, okay, the dates are inclusive from July 22nd, 2010 through May 9, 2011.
Okay, all right, I'll go through them, all right.
Thank you. The second thing to go through, I'll give you the dates. With this, with the previous judges, there was an issue over affirmative defenses. We motioned successfully to get it struck. That came back with the same ones. We had it struck again. That came back a third time. I can give you the dates.
Aren't they affirmative defenses relating to this case?
Well, but the point is, when the court strikes him, and they come back with the same one, and the court strikes him again, and then a third time, the record shows this, I don't think we should be paying for
But
their
that's a legal argument,
disobedience.
let's just please finish the cross-examination.
Whatever, well, I was gonna ask.
Okay, all right, that's fine.
But that's what I was gonna ask.
Okay,
Get
okay.
it
Why don't you
reviewed.
ask the expert?
Have you reviewed the affirmative defenses?
I did see there were affirmative defenses raised. I did see that there were motions to strike. In my opinion, that's just part of the litigation practice in this case.
Did you
And
see,
it's taxable as attorney's fees.
did you see that they were struck and they were refiled?
I did see there were struck and that there were other affirmative defenses filed that were similar to the previous ones. But again,
And then that was the second time, correct?
yes, in my opinion, no, that's just part of this motion practice in litigating this case.
Okay, I'm going to, quickly, do you want the date you want to give it?
Sure.
Okay, the date for those events. 11/24/14, 12/29/14, 4/20, I'm sorry, maybe look, yes, 4/20/15, 5/5/15, 9/25/15, 4/12/16.
Got it.
The last is did you know that there was a motion for attorney fees filed, motion to strike, and it was withdrawn, and it was refiled several months later under a different motion?
I did see that there were two motions.
Do you think the first one that was filed too soon should receive attorney fees? Did you include that in your attorney, in your outlook?
Look, litigation is a messy business. You go through cases like this, you file things, you refile things. I didn't see anything unreasonable in the manner in which defended this case, and I think it's part of the fees that should be awarded.
No further questions.
All right, thank you. Any redirect?
No, Your
All
Honor.
right, thank you so much. Thank you, Mr. Jordan.
Thank you.
Excuse me.
Your Honor, I have a-
Oh, wait. Any objection to taxing Mr. Jordan's fees and costs as an expert in this matter?
No, Your Honor.
Okay, so what's your hourly rate?
375, about 3 hours in this one.
Okay, so the court's gonna fully award Mr. Jordan's $375 an hour at 3 hours, so we'll put that in the judgment as well. Thank you so much.
Thank you.
Excuse that. Let me go ahead and take the rest of the UMC hearings and then, and are you gonna testify as well?
No, but I do have a proposed,
Okay.
bill to what, Judge?
Okay, that's fine. I'll take that.
May I approach?
Sure. All right, we'll take care of that then. All right, thank you guys. Have a wonderful day, everyone.
Thank you.
Thank you. Hold on to that, Michelle. Thank you so much. And this is good. All right, let me go ahead and start UMC hearings. First up, I have, McCracken versus Alani. Motion to eliminate, Council Ray? All right, both sides here?
Yes.
Okay, correct.
Your Honor, I'm on.
Okay, wonderful. It's nice to see both of you. And you guys are special set number 1 for trial. You guys know next Tuesday. Is that correct?
Monday.
Oh, Tuesday. We're starting Tuesday.
We start Tuesday?
Yeah, Tuesday, Wednesday. It's gonna be Tuesday, Wednesday.
Saves everybody.
Tuesday, Wednesday it is. I already ordered the jurors. You guys are good to go. This is a motion limiting specifically number 3, 4, and 5, and number 3 to 1, 2, and 6. So let's do those 3 matters.
Okay.
Your Honor, in the motion limiting number 3, the defendant's husband is apparently in California with severe illness, and the defendant's not going to attend this trial because of this severe illness. I don't think she's gonna be able to testify by way of deposition, and as long as she's not gonna be testifying by way of deposition, I don't want her to be, I don't want the jury to be told that she's.
No, we're not gonna be, Jimmy, how's the defendant gonna testify?
She's not testifying because we've admitted, negligence.
Oh, okay.
All I want to do is make sure we get some sort of instruction at the beginning of trial not to punish her for
Oh,
not
okay,
being.
that's fine. That's fine. I'll give the standard instruction.
Okay.
But what is this?
The standard instruction is that, we don't have to, if she doesn't have to be here, and you shouldn't punish her for failure to not be in court. And you guys can write out some language that you agree to. That's all I'm gonna read.
There's a standard instruction though.
Yeah, there is.
Yeah.
We'll read
So
that.
let's agree to standard instruction. Just make sure, put that on a piece of paper, and I will read that to the jurors during the process.
Your Honor, with regards to the number 4, I believe that they're gonna show me this exhibit, this demonstrative aid,
Right.
and I don't have a problem with it as long as I have the opportunity to observe it before the morning of trial.
Right, all right. And then, number 5?
Number 5, Your Honor, this is a little bit trickier. I'm requesting that the jury make the PIP reductions or no fault reductions as opposed to the judge post.
But we have a standard instruction. Why not go with the standard instruction?
We do have standard instruction, and the notes say that you can do that,
Okay.
have the jury make those reductions.
Okay.
In this particular case, the defense is trying to,
Are you gonna award the full amount of damages, sir?
I intend on awarding what's owed to particular doctors.
Okay.
I also intend on awarding the hospital bill and have my client testify as to what was paid by PIP. I'm gonna put their defense on. The problem in this case is that I think they're stipulated to negligence, but not causation.
Correct.
The ER bill wasn't, the pretrial says they're stipulating the liability,
Okay.
but I don't think that they're gonna be stipulating the causation.
Okay.
This hospital bill is critical to this case. The jury instructions don't say the defense gets the benefit of waived hospital bills.
Okay. All right, let me hear a response.
If you go back to Goebel versus Froman, in that case, it specifically states that anything like a write-off or contractual discount counts as a payment. So when you look at you look at everything and it says payments made, those are payments made. You can award just what PIP paid and not let the jury know that there's a zero balance on that hospital.
Yeah, because then it would potentially be with the windfall for the plan.
But Your Honor, this case has been litigated for a year and a half based on an expectation that there was an outstanding ER bill.
But if there's a zero balance.
It wasn't waived until 2 weeks ago.
But, well, then it is what it is, so.
It's always been waived, we just didn't, we did a subpoena, they didn't give us the bill, so I went back and I did an actual Cicatricus caecum and have them come,
And there's a zero balance.
and there's a zero
There's a
balance.
very zero balance.
Your Honor, the statement says that there's a zero balance, but it's from a person that I don't know has the right to zero the balance out.
Well, then take a deposition, I know.
Well, they scheduled their deposition, they canceled it. I got the bill a couple days ago. I want them to
You want your
prove, I want them to
You
prove.
want your client to owe that money when the client doesn't, they're saying the client doesn't owe the money?
No, Your Honor, they're asking for an instruction on, the initial instruction on causation. And their doctor says this care was reasonable. I get causation if there's an outstanding balance. I get it.
Causation has nothing to do with an outstanding balance.
Well, Your Honor, I guess you're right. I guess you're right.
Yes.
Except I think that, I don't believe that this person had the right to waive this balance.
So that's fine, just take the deposition, that's no problem. You're welcome to take the deposition, so that part of the motion in limiting is denied without prejudice. All right, we'll see you guys at trial next Tuesday. We have the juror questionnaires that we use. It's gonna make your life much easier during the one hour. I think I'm one of the few judges that's using it. But if you want a copy, Michelle can email it to you. It'll make my life much easier during the winter.
That'd be great.
Yeah, it's a written questionnaire. Just contact Michelle, she'll send you a copy by email.
Your Honor, we also probably need a charge conference if there's any way before we do this. Is there any way to do it like Monday at 8:30?
We don't do church conferences beforehand. I mean, just send me, both sides need to send me your proposed or instructions, and then we'll do church conference on Tuesday.
Okay.
Hopefully you guys can agree.
Thank you.
Thank you guys so much. All right, let me please go ahead and continue. Bank of America versus Wadsworth, please. Case management conference. Counsel ready? All right, good morning. What's
Yes,
your
Your
name?
Honor. I don't know.
Oh.
Your Honor, I don't know if the Bank of America's counsel is here.
Okay, let's proceed. It's that though. So what's the status of the case?
Oh, Your Honor, unfortunately, the case has not been moving, and I think that's why you set it for a status
I
conference.
did.
I will tell you this, I propounded discovery to them, which they answered in December and January, just last month. And I've been swamped. I had somebody else handling this who retired. I do need to follow up on some motions on the discovery. And we did have some very significant settlement discussions over the past 4 weeks.
Oh, good, okay.
Well, they didn't result in a settlement, although they did lead to some, narrowed a lot of issues.
Okay.
It's very complicated. The point is, they did send me a modification thing for my client
Okay.
recently. I had a chance to deal with that, but Mr. Loney, who's their counsel, is very accommodating, very easygoing.
Great.
I would say this, though, I know you like to move things along. We probably need a couple of months. If we don't settle the case, I'm going to need to take one of their depots, one court rep depot, and I'd like to get us to a mediation, maybe like by May, and then we could go to trial.
Great, so let me do this. Let me do I'll do another 90-day status conference,
Yeah.
and hopefully you guys can finish your discovery, and then we'll see what the status is at this time.
All right, great.
All right, thank you. Have a great day.
See you.
Thank you so much. All right, Arpaccio versus his agreed order. Arpaccio versus Arpaccio. It's an agreed order. We don't need a court order.
Yes, you do.
On a motion withdraw?
I'm not, it's not just a motion to withdraw, I'm withdrawing, my client here, he asked me to withdraw, but then he has his own motion he's doing without me, Judge. So I wanted to make sure.
Hold on, let me get everybody in here. Okay, all right, so the first thing, let's go ahead and get appearances from all parties, please. We're hearing Arpaccio versus Arpaccio. Could all parties in council please state their appearances for the record?
Lisa Roseman for plaintiff's counsel.
Just say your name.
Chief of Police. Your Honor, if I'm legal,
Yeah, and we have, and Mr. Frash, the special magistrate.
Your Honor, there are two names on the sign-up list, Arpaccio and Arpicio. They're
Oh,
very close together. I think these are the Aparicio.
Aparicio.
Aparicio. Yes, forgive me for interrupting.
Oh, no problem, okay.
But I'm
Aparicio.
prepared to proceed on
Okay.
Aparicio if you like.
Okay, that's fine then. All right, go ahead.
Josie Aparicio.
Okay. Okay, all right, good morning. Very nice to see you. Good morning. So there's an agreed order on a motion to withdraw, is that correct?
That is correct, they had asked me to no longer represent them, so I wish to be excused.
Okay, that's fine. You're gonna represent yourself?
Thank you.
Are you gonna represent yourself?
Well, Michael said the last time. I guess
Do you have a new lawyer? You're gonna represent?
No, I don't have a new.
Okay, all right. The next one is a motion to enter into the sales contract and a motion for special consideration regarding sales contract. You may proceed.
May I be excused, Judge?
Of course, have a great day. Sorry, go.
Good morning, Your Honor. Your Honor, this is one of those difficult cases where no matter what I do, I'm going to make everyone happy, and unfortunately, I must proceed at this particular time. And Mr. Owen, the listing realtor, sends his apologies. He had some emergency treatment, and he couldn't be here today, but he's been working hard on this matter. Mr. Owen has informed me that he has taken approximately 100 calls with regard to the property and has shown the property. As the court knows, there are, I believe, 12 folks living in the home. It's a nice home, but it does need a good deal of TLC.
Okay.
Recently, one of the family members has come and cleaned up the property. I did confirm with the broker, the realtor, what the status was of that property. So it has improved current value, but probably by $3,000 or $4,000. There's just so much work that needs to be done. In addition, Your Honor, our research has indicated that there are pending code enforcement liens or that are floating out there. Mr. Owen worked his magic, as he always does. He went down to the city of West Palm and he got them to put everything on hold and explain the situation to him. We are concerned as well that there is an unpermitted structure on the property, Your Honor, and an unpermitted connection to sanitary. Having said all that, we've lost two offers within the past month because the process just takes so long.
Yeah.
This is a home for investors, not for homeowners, because it needs a good deal of work. Investors have to come in and move fast. We still have the lead offer, which is a cash offer. We've confirmed it's cash.
Okay.
We've confirmed the bank account amount. It is certainly not as much as we would like to get for the property. It is not as much as Zillow shows, but Zillow obviously is a computerized database that overgeneralizes.
Okay.
We've spoken to the Aparicios. Mr. Owen has spoken to the Aparicios. We'd love to sell it to keep it in the family. But at this particular time, the differential we offer and the other offers is about $15,000 plus what's going to end up happening. Ms. Aparicio would have to get an FHA loan, and as the court knows, an FHA loan is going to require investment, it's going to require appraisals as well as inspections, and then that would
Delay, sure.
well, not only that, but it would show those particular issues that we found in the public records, which would create an impossibility to close.
Okay.
So this is the best offer that we
You're
found.
recommending a cash offer?
Yes, Your Honor, we are. The cash offer is, and as is with due diligence provision, we'd like to be able to accept a backup offer if we can.
Okay.
But this is the best we have. Additionally, Your Honor, we would need some closing instructions to myself as special magistrate. When the court has appointed me in the past, what the court has done is instructed me to sign the documentation, obviously reflecting on special magistrate, not the owner of the property.
Sure.
So forgive the long explanation. That's where we're at. The Aparicios did want to come here and tell you their position, and I told them the best way to do that was to file the paperwork, which you did, and also come here and explain the situation to you, Your Honor. And I apologize, Your Honor. Mr. Owen and I have worked very, very hard. We wish we could have gotten this property at its 220 to 230, what we believe to be its intrinsic value, but and we have photos as well that we've provided the court. But in its present state, and under the present circumstances, it would be very difficult to do that, and we are afraid if we delay any longer, we're going to lose the last cash offer that
All
we
right,
have.
thank you so much. Let me hear from both sides. Let me start with Ms. Aparicio.
Yes, as the magistrate said, we were able to get a FHA loan as well as an FH loan with a 203K, which it will help us bring the property to a FHA approval.
Okay.
So I understand it's timing. Everything's timing.
But the problem is there's code issues, so it may not go through. That's my concern.
Well, they did not make us aware of what code issues are. We will find out.
There's a structure on the property that shouldn't be there. The city's not gonna like that. It won't pass code, it won't pass inspection. It won't pass appraisal, that's the problem. An FHA loan is not easy to close.
Okay, well, the only thing is then, the only thing I have to ask my brothers if they're willing to sell us directly. Meaning, my dad and my sister is willing to pass the 1/3, like a quick claim.
Okay.
So the ownership makes it easier to get it from.
Can you put that in writing then?
Yes, we
Okay,
can.
all right, let me hear from.
Well, first of all, let me say good morning to all. And my name is Giovanni Aparicio, Adelino Giovanni Aparicio. I'm the owner, same as my brother, which was also my dad, but he currently gave the deed to my sister who's here. But I have two things that I have to say, and be very clearly. We try to keep the house clean all the time. I was there living as well, working, and nobody, actually, the person who lived there, like my two sisters, they never actually took an effort to help us clean the house or stay into code. They didn't respect us. And so that's why the issue of the house and value of the house became so bad. And also as well, they didn't help us clean the house, they didn't help us do anything. They were living for free for 4 years. My brother was living in his own apartment, paying his own rent. And obviously we came to this big issue to be able to live together with no respect to each other. So, I mean, there was nothing we couldn't do. I tried to improve the house. It's just
Are you okay with the cash offer?
I don't know the cash offer, but I have also a neighbor that tried to get into it. He was offering 190,000, and he had been approved by his lender. But like again, about the issue about he needed to put a 10% down and another 10%.
Financing or different.
Financing. He told me he was willing to work with us, and he's ready to go for it. But I said we gotta hear, we gotta listen to what the court is. But we're ready to sell whatever.
You're okay with the cash offer?
Yes, I'm okay with it.
All right, is that okay with you too?
I want to sell it because I want to
Yeah, no,
live my
it'll be
life
fast.
and have my own.
Easy, fast close. Are you okay with the cash offer?
Good morning, yes, James Aparicio with the record.
Okay.
Yes, I'm good with the cash offer because it's been taking several years to proceed with this.
Okay.
And they had a lot of chances. We gave them the opportunity to solve, to get it purchased through them a year ago, but since now they want to do that, but it's going to delay on this.
Okay, all right, I'm going to go ahead and grant the special magistrate's motion to enter into the sales contract for the cash offer. And you can certainly go ahead and sign as a special master as well. The funds will be in your trust account, and then I'll deal with the disbursement after that. All of the cash will be put into your firm's trust account.
Yes, Your Honor, in lieu of putting into the court register.
Yes, exactly. That'll save expenses as well. So we'll use all the money from the closing, we'll go into the special magistrate's trust account, and we'll he'll give us a detailed accounting of everything, and we'll make sure all the i's are dotted, all the t's are crossed, everybody knows where every penny is going as well. And it'll be a quick close, so that way we'll get everybody paid very quickly as well.
Thank you. Thank you.
Your Honor, as far as timing to move, how long are you allowing us?
When are you going to go do, when does the proposed sale?
Mr. Owen worked his magic again, and he got an extended period to close
Okay.
in order to allow the families who are living there ample time to.
Okay, so is it 30 days, 60 days?
I believe it's 60 days.
60 days,
But
okay.
the investor has been willing to work with us.
Okay.
So I think we'll be able to.
So we'll make sure you have enough time to do it.
Thank you.
Okay, and if for some reason you're able to match the cash offer or come up with a better number without an appraisal that won't be an FHA loan, certainly you can file that and we can take care of it. You can get with a real estate agent right away. We want to try to get you the most money, but we want to try to get the house closed so this family can go on, to better things.
Yes, please do that because it's been a long fight. It's a horror fight, but it's time for us to move on.
You guys, I want peace in the family,
Peace.
okay?
We had this is America, and where everybody can move on in life and do their own what's best. for them.
Everyone can do what's
Thank
best for
you.
themselves, okay?
Thank you.
Good luck to all of you. Thank you so much.
Thank you, Your Honor.
Very good, Your
All
Honor.
right, thank you so much. Excellent work as always, Mr. Parrish. Thank you so much. Have a great day, everyone. Michelle, here's all the paperwork. All right, so and here, Michelle, here's the six ones. City mortgage versus Doucette, please. City mortgage, Doucette, motion to cancel and reset foreclosure sale.
Yes, Your Honor, good morning.
Good morning. It's motion to cancel and reset. When would you like the sales?
Judge, if we can have it set out at least 60 days.
Is that okay? 60 days for sale?
John Carlo, and we had no opposition to that sale date. I believe my client's been working on getting the loss indication before the sale team.
Okay, so we'll cancel and reset, 60 days.
I have an order from
That's
everyone.
fine, just hand it to the bailiff, please. Wells Fargo Bank versus Dicer. Motion for extension of time. Good morning. It's the motion for, or the motion for extension of time, which I read. Any opposition?
Your Honor, just the only issue we've got, this was filed back January, so I'd asked something to be responded to in 10 days.
10 days. Is 10 days good?
That's fine, Your Honor.
Okay, we're going to go ahead and grant it, stand up in order, and 10 days it is.
Thank you.
Thank you, guys. Have a great day, everyone. Let's go ahead and please do another foreclosure. City Mortgage versus, oh, we just did, okay. One West Bank versus Robinson, please. Motion to correct Scrivener's error and the final judgment, or an alternative motion to vacate final judgment, enter new final judgment.
Yes, Your Honor. We spoke to Mr. Robinson, and he has no objection.
Okay, I'll grant it and then we'll close the case.
Thank you. And if I know in our proposed order, the last paragraph 3 has to vacate the final judgment. If you just want to, I can strike that.
Yeah, Michelle, go ahead and hand me the order and then help us.
I have them here,
Oh,
Judge.
okay, perfect, that's fine.
Thank you.
Kimball versus Wellington. Come on up on Kimball versus Wellington, everybody here?
Your Honor, the co-defendant's attorney for Wellington Regional sent me a message that she's running a few minutes
No problem,
behind.
we can wait. No problem at all.
Thanks, Your Honor.
Okay, all right, let me go ahead and please do Data 1 versus Data 1, please. Motion for entry, final judgment. Counsel Reed? All right, good morning. This is Data 1 versus Data 1,
Yes,
and I
good
read
morning, Your
everything ahead of time. Everything looks to be in order. Is there anything you'd like to add?
No, Judge, I did a proposed final judgment with envelopes to the defaulted parties.
Perfect, we'll take care of it.
All right, thanks, Judge. Have a good day.
Thank you so much.
Good seeing you.
Good seeing you as well. City mortgage due set, we just did. Multiple copies of that one. Okay, Rodemeyer versus Classic Nursery. Council reading that one? Good morning, Your Honor. Good morning.
Good morning, Your Honor.
All right, this is Rodemeyer versus Classic Nursery.
Yes, Your Honor.
Discovery matters, we have a court clerk.
No, Your Honor.
Okay, all right. This is plaintiff's motion to overrule certain objections, so we can go through.
Good morning, Your Honor. William Brennan on behalf of the plaintiff. We actually have just resolved right now all discovery disputes.
Great.
So I'm going to submit a proposed order to the court.
Excellent.
There is one matter I can address with the court. I filed a motion to roll over the case yesterday, and opposing counsel does not object to it. Our client, we found out last week, is not at MMI and won't be so for a while.
I'm happy to roll it. When do you guys know, do you want to know which document?
We're looking for September.
September, guys? Okay. Good.
Do I need to submit anything with regards to that?
We'll send you neutral or something.
Thank you very much, Your Honor.
Thank you, Your Honor.
Have a great day.
Thank you. Thank you, guys. Have a great day then. All right, let me go ahead and please do Kaufman versus Coulter. Motion to adjourn trial. Counsel Ray? This is Judge Curley's case. Come on up, everyone.
You may recall, these are the cases that came over from Judge Rowe.
Oh, sure.
So
Absolutely.
you had set it for an April 1st trial. I have a special set in Collier County starting that day.
Do you guys want another day?
Yeah, and I don't think there's any opposition.
There is no opposition, Judge.
I'm happy to do it whenever you guys like to. When would you guys like to go?
Anytime after the summer due to some vacation schedules of people involved in the trial.
As long as that's okay with everyone, that's fine with me.
Yeah, September, October. Does that work?
September, we'll put you guys on the September docket. Is that all right? Perfect, it is. It's great.
Thank you, Judge.
Thank you, guys.
Thank you.
Have a great day.
Thank you.
Make your life easy as possible. Thank you, guys. September it is. All right, Dennis versus Comcast. All right, good morning, everyone. This is Dennis versus Comcast. Could counsel please make their appearances for the record?
My name is Mark Heckner, and I represent Boca Town Center Condominium Association. It's my motion to dismiss, Your Honor.
Good morning, Your Honor. My name is Maria Gonzalez, and I represent Comcast.
Good morning, Your Honor. Three Lamar, the plaintiff.
All right, good morning. It's a motion to dismiss at Boca Town Center, and I read the motion, and you may proceed with the motion when you're ready.
All right, three things I'd like to bring to the court's attention, Your Honor. First of all, what the complaint alleges is that the plaintiff was operating some heavy equipment on the public sidewalk, and that some wild animals, some bees, came out of a Comcast box and swarmed around him, and as a result of that, he jumped off his heavy equipment.
Okay.
There's no ultimate facts pled with regard to my client that would have proven at the time of trial that my client's responsible for another's property.
Yeah, can I ask, what did the town center do?
I'm sorry?
What did the town center do in this situation?
The town center owned the property in which the gutted cable box that was abandoned contained the beehive and the stinging bees right by the edge of the site.
Vicarious liability, is that all this?
Well,
Just through the owner, there's no actual negligence, you're just saying.
well, yes, they agreed to the installation and the keeping of that gutted and abandoned cable box there, so they are actively negligent. We have, that's count one.
Okay.
They're actively negligent. They should have maintained a safe and hazard-free property, and they did not. And when he was working there, they came.
Where is that planted complaint?
Your Honor, I filed a response in opposition. Did the court receive it?
Yeah, I did, but I can't consider the allegation in the response. It has to be in the complaint itself.
It is in the complaint.
Where is that in the complaint?
The court's specific question regarding where, I'm sorry, maybe,
Yeah, which paragraph in the complaint?
of what point?
Of the one, that the allegations of negligence on behalf of Boca Town Center.
Yes, Your Honor. Okay.
I'd like to give it.
No, I'm here, I was asking counsel.
In our response in opposition.
No, not the response in opposition. Where is it in the complaint? I can't consider the response in opposition.
No, I'm sorry. The response in opposition contains every statement of the complaint.
I can't consider the response in opposition. It has to be on the face of the complaint. That's what I meant?
No.
Then where is it in the complaint?
At the paragraphs which are stated in our response in opposition.
Which paragraph? That's what I'm asking.
But which point is the court? Just negligence?
Where you're alleging any negligence on the part of Boca Town Center?
Yeah, okay. Give me a moment.
Sure.
Let me go to the minutes now. We stated in paragraph 9 that the defendant failed to keep the property secure. And we're talking of all defendants, each defendant named failed to keep the property.
You need to indicate what they did.
That they maintained an abandoned cable box that contained bees.
Where is that?
I'm continuing on.
Okay, sure.
That paragraph 10, that this defendant owned the property. Paragraph 11, that there was a duty to keep the property free and safe. Paragraph 12, that there were injuries. Paragraph 13, that the defendants created this particular dangerous condition. Paragraph 14, that the defendants knew of this particular dangerous condition.
You need to say what that dangerous condition is.
I did.
Where is that in the complaint, sir? Where is it talking about the bees in the box?
All over our response in opposition
No,
to
sir.
our motion.
Motion to dismiss is granted. You have to put that in the complaint.
It is in the complaint, Your Honor.
Where are the words bees?
Well, then I have to continue and go through the complaint. Paragraph 14, that the defendants knew of the bees being on the property.
Okay.
Paragraph 15, that the defendant Town Center was the owner of the property and knew of its construction and that the bees were in the box, in the beehive.
Okay.
Paragraph 16, that the defendant Town Center failed to maintain the safe box and the safe premises.
Okay.
Paragraph 17, that they owed a duty to him. Paragraph 18,
That's
they
not, let me
failed.
hear it from the bottom, please.
Paragraph 9, Comcast owned, installed, and then abandoned the subject cable box. That's, I'm sorry.
That's just paragraph 9. At least a dozen other times in this
Stop,
complaint.
hold on, go ahead.
That's what's alleged. My client didn't own it, didn't install it, had no dominion, no
You're
authority.
alleging it was a Comcast cable box.
No, right, no rights over it. It was on an easement. And so, going back to what I originally argued, there's no ultimate facts alleged, which put
Yeah,
on
what did
the
the
trial.
town, what did the mall do about the box? It's a cable box belonging to Comcast.
Every one of our paragraphs, Your Honor, up to paragraph 26, half those paragraphs state that the defendant Town Center owned the property, they allowed the box on it, they agreed in writing, we know now because of a motion they filed today for a cross litigation complaint from Your Honor.
Okay, motion is Mrs. Grant. Just go ahead and amend. How much time do you need to amend?
I don't know of anything else I can amend because we've stated it in the complaint. We can change the paragraphs around and renumber
Then
them.
don't indicate that Comcast owned and was responsible for the box. Indicate that the Boca Town Center was fully responsible for the box then.
Boca Town Center's motion, which we're here before now.
Okay, motion's to be granted then, okay? Thank you. Have a great day. Okay, 20 days to amend. Yes.
Yeah.
Your Honor.
My client also filed a motion to compel plaintiff's deposition to be heard today. Essentially, we've been requesting for dates and we haven't gotten dates yet.
Your Honor, that's not true.
Okay.
Last week, we gave them 6 dates. Her office sent back that they would like one of those dates, April 26th. We say we have many dates, so that motion should have been withdrawn because that was
So do we have a date that everybody agreed to?
Your Honor, I spoke to the attorney handling this, they did not
Counsel
advise
saying he
me.
gave a date yesterday.
Who gave them Friday?
Oh, on Friday, yeah.
I don't
6
know.
days.
I don't know how we can do a deposition without the pleadings being set. Am I going to be in the case? I mean,
I don't know, the deposition can proceed, okay? The motion, since Mrs. Graham deposition can proceed, and we'll do it on the date that you want.
I
Okay,
gave
6
the
days.
date that they want, I gave them 6.
All right, that's okay.
Great.
All right, thank you guys. Have a great day. Thank you so much. Let me go away, please, to alternate versus citizens. Council ready, number?
Good morning, Your Honor.
Good morning. This is alternate versus citizens, and this is defendant's amended motion to strike the plaintiff's expert witness.
Yes.
And alternate motion disclosed.
Yes, Your Honor. And I received an email
They're going to be
from,
telephonic, right?
Yes.
Okay, let me go.
I was given the number 786
786
363
Uh-huh.
4657.
4657. Let me give them a call.
Okay.
Good morning, this is Max Santiago.
Oh, good morning. This is Judge Sasser. I'm calling in alternate versus citizens. Are you ready for the hearing?
I am, Judge.
Wonderful, thank you so much. This is defendant's amended motion to strike plaintiff's expert witness on the alternative motion to disclose as the expert, and I read the motion, you may proceed. So you have another witness now, is that correct?
Yes, Your Honor. So we're asking you to strike Al Brazuela, who was plaintiff's expert that was disclosed after, and we detailed it in the order. Then we subpoenaed him, he refused to appear. Then we worked with Mr. Santiago's office to finally have him appear in early January. And then for the first time, he says, I've never inspected the property. It's 4 years, 8 months after the fact. I don't know what the cabinets are made of, but I'm going to now come in 5 years after the fact and render some opinions in this case.
Well, actually, I can't really strike a witness. Why, we can go ahead and, I'm in the alternative to go ahead and disclose the defense expert, that's fine. We don't like to strike witnesses, we know that.
Okay, so motion to strike denied, motion to disclose Ralph Moon
It's
granted.
granted, yeah. Any opposition to that, that's fair to both sides. At least that way defense has an expert, plaintiff has their expert, and we can proceed.
Judge, actually, I do have an objection, and here's the basis of my objection. The defendants already have an expert by the name of John Carroll, who's an engineer. Now, I've already taken John Carroll's deposition. He's going to testify on causation. He's going to testify that the damages were long-term, which supports their denial. What they're asking to do, in essence, is to bring in another expert who's also an engineer, strictly for purposes of impeaching Al Brazuela, our expert. And it's not permissible under the rule.
Let me ask defense counsel, what's your new expert going to testify to?
Ralph Moon, just to go back one step, Your Honor, Al Brazuela came in, who's an engineer, who said, my opinions are based upon Ralph Moon studies, right? Ralph Moon studies, right? I've never tested a piece of wood in my life, but I'm going to come and testify about it. So we went out within a week of Al Brazuela's depot and retained Ralph Moon and did an amended disclosure. Now I've asked
Are
you
you
to...
going to have both experts testify?
Yeah, because John Carroll inspected it, and as an engineer, Ralph Moon will be talking about his studies that he personally done about water dripping in these cabinets and how long it takes for the damage that we see in these pictures to how long it takes.
Okay.
How many months, years.
All right, I'm going to overrule the plaintiff's objection. We'll go ahead and allow it, but you can certainly make a contemporaneous objection. I won't allow cumulative testimony at the time of trial. But I'm going to deny the motion to strike plaintiff's expert. I will allow the additional defense expert, but no cumulative testimony.
Okay, just one other matter. We are set to begin trial
Next week. Yeah.
That's what I was going to...
Now,
Thursday, Friday.
we haven't had the benefit of taking Dr. Moon's deposition.
Yeah, I'm going to make him available. Can we have Dr. Moon available for deposition before trial?
Yeah, can I find out what his availability is too? And I was going to bring it up because yesterday in getting ready for the hearing, I was told by my office that we were supposed to be number one Monday and then...
No, but that trial from the other one, they couldn't go last week because they had an issue, so that's why I had to bump them to next week. So you guys are number one Thursday, Friday.
Okay, because then this is my problem, because I was told we were bumped to Monday afternoon, starting.
Thursday, Friday.
And then I know just earlier, there was that auto case that's
They're going
starting
Tuesday, Wednesday.
Tuesday, Wednesday. I'm supposed to be leaving out of town Friday, so I always thought we were starting Monday, and it was.
Yeah, that auto case has to go. I can switch with you guys. Do you guys want to do Tuesday, Wednesday? I can switch with the auto case.
But I think you have this listed as we have it listed as a 4-day case.
I just take 4 days in a water case.
But even, what I'm just concerned about, Judge, is I have a ticket to leave Friday out of Miami.
Then do you want to do it Tuesday, Wednesday? I can ask if the auto case can switch with you guys.
If it's okay,
Yeah.
I can check my.
Why don't you do that?
Okay.
We'll just switch with you guys. We'll do the water case Tuesday, Wednesday, and the auto case Thursday, Friday, if that works. I'll
Yeah,
switch.
that's fine. Let me just check and then see what Ralph Moon's availability is to make him available.
Yeah, we'll take care of that. That's no problem.
Okay, and then so we should find out.
Michelle's going to email you this morning, as soon as we check with the other case. We'll work around your schedule. That's no problem.
Okay, thank you.
Thank you, guys. Have a great day. Thank you all.
Thank you, Judge.
All right, let me do Kimmel versus Wellington. Come on, guys. All right. And this is a motion to compel the corporate. Okay, this is Kimmel versus Wellington. This is defendant's motion to compel the update deposition of the plaintiff. And do we have additional counsel involved?
We do, Your
Okay,
Honor.
which number should I call? Plaintiff or defendant?
Plaintiff.
Okay, let me call him.
I'm here, Your Honor. Thank you
Oh,
for waiting. I
okay,
appreciate
no problem,
it.
no problem at all. Let me give him a call.
Good morning, this is Josh Wintle.
Oh, good morning, it's Judge Sasser. I'm calling you in Kimmel versus Wellington. Are you ready on the motions?
Yes, Your Honor.
Great. This is defendant's motion to compel the update deposition of the plaintiff, which I read. And I know that I read the motion, I read the response. So you may proceed when you're ready, guys.
Okay, Your Honor, I know you read the motion. It's pretty clear. We haven't deposed plaintiff in 3 years. We have trial coming up. Last time you saw us, you granted the motion for updated interrogatories. We should be entitled to see how he's doing now, what he's been up to. We will not revisit liability.
Okay.
It's pretty straightforward.
Damages. All right. Any objection, counsel?
Yes, Your Honor, this is the third deposition that's been sought by the defendants in this case of Mr. Kimmel, not including, of course, the pre-suit statement under oath. This third deposition is unwarranted. It's unduly burdensome. The motion really is just a copy and paste of the exact same motion to compel filed a few years back, and nothing has changed. Your Honor just recently ordered Mr. Kimmel to provide updated answers to the 4th supplemental interrogatories.
I did.
Which is going to cover the same issues, and those answers are going to show that he's had no new related medical care, and his injuries are still permanent, and the difficulties he has today are the same difficulties he had at the last time his deposition was taken, which was back in 2014.
Then it should be a pretty brief deposition. So I'm going to grant defendant's motion. You can just do, again, we're not going to revisit liability. It'll simply be his current status as to his damages as well. So I'm going to grant defendant's motion.
Okay, thank you, Your Honor.
And then you guys are coordinating with your dates on the trial.
Yes.
So I'm going to special set you guys whatever works best and just let Michelle know, and we'll send you guys a new trial over as well.
Perfect, Your Honor. I have the order now.
Just hand a copy to you. Yeah, have a great day, everyone.
Thanks, Your Honor.
Yeah.
And one more telephonic, and let me take care of that one.
For calling the conference center, please enter your PIN, followed by... Thank you. After the tone, please state your name, followed by the pound sign.
Judge Sasser?
Thank you. You will now be placed into conference. There are 3 participants in the conference.
All right, counsel, you ready on the hearing? This is...
Join the conference.
Oh, counsel, good morning. This is Judge Sasser. I'm calling you on Law versus Universal. Is everybody ready on the hearing?
Yes, Your Honor. Yes, Your Honor.
Wonderful. This is with regards to the hearing on the plaintiff's motion to compel compliance with the court order. I had an opportunity to review the motion and the response. Counsel may proceed when you're ready.
Your Honor, good morning. This is Percy Martinez on behalf of the plaintiff, Davida Lacka. As the court well knows, entered an order that on January 4th of this year requiring the defense to provide deposition dates within 15 days. That is, by January 19th, they had to provide those dates. They did not provide those dates.
Oh, okay.
I'm asking for the inclusion of the field adjuster This is a field adjuster that we've been trying to depose for quite some time. This last year, we've sent multiple emails. We've actually pushing back support for intervention. The court has this order. They've ignored this order, and they filed an untimely motion to extend compliance with the court order. They filed it on the 21st, citing holidays, the holiday season as an excuse for not complying with the order, when they had told us that this field adjuster, Jordan Geller, was an in-house universal field adjuster.
Okay.
And still, they ignore the court's order, and I'm asking for Mr. Geller's exclusion.
All right, thank you so much. Response, please?
Your Honor, we are aware of the court order, and
Why didn't we have compliance with the court order?
I'm sorry, Your Honor?
Why did we not have compliance with the court order?
Unfortunately, my assistant was out on vacation about the time the dates were due. It went to another assistant in my office. They did provide dates for the corporate representative of the defendant, and that date was coordinated. When I was not made aware that the field adjuster had not been coordinated. It was my understanding that my office is in the process of providing those dates. When I received an email from Mr. Martinez, from plaintiff's counsel's office, advising that the field adjuster's date was still outstanding, I responded and I contacted the field adjuster. We got a date to them immediately within a day of notifying that it was still had not been set. That was on February the 4th, Your Honor. We provided a date. Plaintiff's counsel's office said that date was not available on their calendar. My office responded that, and furthermore, the plaintiff's counsel would be out of the office for a significant time in April. And so in response, my office provided a couple of other dates, or requested other dates so that we could take it back to the field adjuster to coordinate his availability during time frame that plaintiff's counsel would be available. That would just be easiest if we had dates from plaintiff's counsel's office that he was available, and that way we could take it and coordinate it. I extended that offer to plaintiff's counsel on February the 4th. Maybe February the 7th. My office did on February the 4th. From February the 4th until today, plaintiff's counsel's office has not provided any dates that they're available. They've not suggested any other alternative dates. I advised the plaintiff, when I spoke with the field adjuster, he said that he was available at any time in April, and that's all we were waiting for was available dates from plaintiff's counsel's office.
Okay, any rebuttal?
Judge, my rebuttal is April 4th would have been the cutoff date of the 90 days within which the depositions hadn't been taken, and that wasn't the dates that were provided to us, and we told them as much, and we said, those dates are not good, they're beyond the date that the court has set. Moreover, I have a 2-week period of vacation in late April that doesn't in any way, shape, or form obstruct my ability to take the deposition in this case, although that would be beyond the April 4th, which the court already imposed as the deadline for the deposition to take place.
Okay, all right. So, but I can't strike a witness, that's the problem. Appellate courts don't like courts to do so. How can we cure the prejudice at this point in time? I made the witness available, and let's just proceed at this point in time.
Judge, I would ask the court, I would ask the witness to be made available by this Friday.
I think that's fair.
The field adjuster, my client, this is a first party case, my client's living in a mold-ridden home. She's having health issues, and I need to get this case moving along. It's not moving along because they're dragging their feet, we're not providing these dates.
You're exactly right. No. Date by Friday. Date by Friday. Date by Friday.
Sorry?
Date by Friday.
A date by Friday?
Yes.
Absolutely, that's no problem.
Okay, let's move this case along.
Is there a timeline? I was not aware that, I thought that May the 10th was the deadline to have the deposition done.
No.
It can be done sooner if they're...
Let's do the deposition, let's say within the next 3 weeks. Date by Friday, deposition within 3 weeks.
Okay, I will make that happen, yes, sure.
Okay, all right, that's fine then. So I'm going to deny the motion, I'll grant the motion to compel compliance with the court order. Date by Friday, deposition within 3 weeks. Otherwise, at that point in time, then I'll do an order to show cause to strike the witness.
Yes, Your Honor.
All right, thank you guys. Have a great day, everyone.
Thank you.
Thank you. Okay, all right. Pete, I think we have a quick 9:30, but otherwise.
We do, Judge.
We took care of all Judge Curley's orders and everything seemed to. Are you here on the 9:30? Or right motion?
Yes, Your Honor, 9:30.
Are you expecting anybody else?
By phone, Your Honor.
Oh, okay, that's fine. Let's go proceed.
I'm the court reporter.
Okay, sure. What's the phone number for the 9:30?
Your Honor, it is, Frank DeLuca, he's at 954-822.
822.
4954.
4954. Let me give him a call.
Sir, can I have you identify yourself for the record?
Christian.
This is Frank DeLuca.
Oh, good morning, Mr. Luca. This is Judge Sasser. Are you ready for the 9:30 hearing?
I am, Judge.
Wonderful. Oh, no problem. This is, I'm calling on Costner versus Henry Schein, and we have a court reporter. This is defendant's motion for summary judgment, which I had a chance to read, and you may proceed with additional argument on your motion at this time.
Yes, Your Honor. As you've read the motion, it's a very basic argument. It's unopposed, Your Honor. At this point, we've met with all parties. We've discussed the motion. No one opposes entry of summary judgment. In fact, we've passed around an order granting summary judgment as well as final summary judgment.
Oh, great. Okay. All right. Mr. Luca, do you agree? Everything good on that?
I do, Judge.
Okay.
We've seen the proposed order, and we agree to the proposed order.
Wonderful. If you just email that to the court this morning, I'll be happy to sign it and take care of it for you.
Thank you, Your Honor.
Thank you. Nice seeing you. Have a great day.
You too.
Thank you so much.
Thank you, Judge.
Thank you. Have a great day, Mr. Luca.
You do the same, Judge. Bye-bye.
All right.
Thank you, Your Honor.
Thanks, Pete. Have a great day. We'll have to, we'll work on this.
That was good, Judge.
Oh, good job. He's so good.